Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa, PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show. Today we're going to talk about 10 warnings for auto accident survivors, how to get information from your soon-to-be ex-spouse, and the reversal of Bill Cosby's criminal conviction. Stay tuned.
In the name of criminal defense.
Many people were stunned when Bill Cosby was accused and then convicted of sexual assault. And then they were even more stunned when his conviction was reversed on appeal. I'm here today to speak with experienced criminal defense attorneys, Mary Chartier and Takura Nyemphakusa of the firm Chartier and Nyemphakusa, to talk about this case. And for those of you who may not know, Mary and Takura, what was the accusation against Bill Cosby?
The charges that he went to trial on stemmed from an allegation that was made in the early 2000s. A woman claimed that she was sexually assaulted by Mr. Cosby. She went to the police roughly a year later. In between that time, she had gone to see civil attorneys, and ultimately he was charged and convicted in 2018. There had been a first trial and there was a hung jury, which means the jury couldn't decide whether he was guilty or not guilty. Prosecutor recharged him, and then he was convicted in 2018.
Okay, so what was the main reason for the reversal of Bill Cosby's conviction?
Well, Lisa, it's important to go back a bit. As Mary mentioned, Bill Cosby was being sued civilly by a woman who said she was sexually assaulted by America's dad, which means she wanted money, a whole lot of it, right? And because Cosby could be prosecuted for sexual assault, he had the right under the Fifth Amendment. We've all seen law and order. You have the right to remain silent, that whole thing. And for that reason, being called at the deposition, he didn't have to say a word. But I guess the prosecutor decided, you know what? I'd rather have his statement. So that prosecutor decided, Mr. Cosby, as long as you testify, we won't prosecute you. Now, this former prosecutor—
Just to clear, as long as you testify in the civil case that has been filed against you, whatever you testify to in the civil case, we won't use against you in a criminal case. Is that what you're saying?
Well, and even more than that, though, it's not just that if he testified in the civil case, they wouldn't use against him in the criminal case. They agreed not to prosecute him in the criminal case. So it was two prongs. It was not just what you say in the civil case, we won't use against you. It's we're not prosecuting you at all. That was the agreement.
The prosecutor who made that agreement, unfortunately, went off, and the new prosecutor said, oh, no, I don't care what that other prosecutor said. We're going to charge on and go ahead and prosecute him.
After he testified, they changed their mind?
Right.
Okay. So,
right.
So what was the reversal about then? Was it related to the agreement?
It was based solely on this agreement, although the opinion discussed other things. But it really delved into this, Bill Cosby and his lawyers relied on the agreement with the prosecutor that they would not be prosecuting him. And the prosecutor had said he assessed the case, believed that it would be very difficult to get a conviction, and then made the decision to not prosecute him. And that allowed the complainant to sue him civilly and get his answers and therefore get money. And he thought, well, at least she'll get something, right? She won't have a criminal case that goes forward, but she will have a civil case in which he has to answer questions. And the whole opinion was about, as Takura said, this bait and switch. Mr. Cosby and his lawyers relied on the agreement with the prosecutor's office. Doesn't matter if a new prosecutor steps in, or at least it shouldn't matter. That was the agreement. The new prosecutor not only breached the agreement and tried him, but then used his statements in the deposition against him. So the only reason he made statements in the deposition was because the first prosecutor said, we're not going to charge you. And so therefore the statements wouldn't be admissible in a criminal case because there is no criminal case. And then that new prosecutor used the statements and tried him.
So what court overturned the conviction?
This was the Pennsylvania Supreme Court, Liisa.
And it was a 79-page opinion. It was lengthy. That's a lengthy Supreme Court opinion from a state Supreme Court.
I was just going to add that the court basically said that, look, prosecutors have a lot of discretion in their charging decisions, but that decision has to comport with the Constitution and due process. It's not unlimited, right? And prosecutors have to live up to their agreements just like anyone else. They're not special in that respect.
Okay, so moving from prosecutors to the police, can the police still lie to suspects?
They can and they do, right? They can and they do. This doesn't pertain to the police, although we've argued and lost that the police shouldn't be allowed to lie, right? The police shouldn't be allowed to lie. They shouldn't be allowed to make an agreement and then breach an agreement. They shouldn't be allowed to tell someone, well, if you say X, Y, Z, or you talk to me, I'll go to the prosecutor and try and help you out, when they know they're never going to do that. And we know they're never going to do that. That's a lie. That's like, I mean, you have more rights against someone lying to you when you go to buy a lawnmower than you do when you're in a room with seasoned police officers or even inexperienced police officers. I mean, they can lie with impunity about absolutely everything, and they do. This opinion doesn't address that, because we do have U.S. Supreme Court case law that says they can lie about facts. Now, I think there's a difference between facts and an agreement, right? Facts in the terms of someone coming in and making a statement. I have so far lost all those arguments in court, but so did Bill Cosby's lawyers. They raised this issue, right? They raised this issue every step of the way and fought really, really vigorously to say this was an agreement that was made with the prosecutor. A new prosecutor can't come in and breach it. And they lost every step of the way until they got to the Supreme Court.
Well, now that the conviction's been overturned, does that mean there will be a new trial?
I doubt it. I mean, what do you think, Takura?
You know what? Given the amount of money and effort and everything that they went through, possibly, it's possible, but I don't think it's probable. How about that?
Another part of the opinion, and they didn't get to the make a ruling on it because they decided on the agreement, but another significant portion of the opinion was related to what's called other acts evidence, which is not the person. So if I say Takura punched me in the nose, which I know you would never do, but if I say that, and then I know you would not, right? But then he's prosecuted, and the prosecutor wants to bring in 3 other people who say Takura punched them in the nose. That's other acts evidence. And there are really, supposed to be strict rules on when that can come in, because propensity, the fact that he might like to punch people in the nose, is not what he's on trial for. It's, did he punch me in the nose? Those rules are relaxed in Michigan in cases of sexual assault and domestic violence. The prosecutor can try and get in evidence of propensity, that this person has done it before and they'll do it again. There are ways to try and keep it out, but if you're looking at the scales, they tip toward the prosecutor. But the Pennsylvania Supreme Court, while they didn't address that issue in terms of make a ruling on it that's binding, they did talk quite a bit about it, because other women were allowed to testify in Bill Cosby's case. If there was a retrial, my assumption is, that I don't know if all those people would be allowed to testify again. I mean, just based on the way that the court wrote its opinion.
And this incident was alleged to have happened in 2004. Is there no time limitation for sexual assault?
Well, there is, depending on, on the state that you're in, but she would have, she went to the police in a timely enough manner, and Bill Cosby was charged in a timely enough manner that the statute of limitations didn't run in that case. But in a lot of states, for the highest count of rape, there is no statute of limitations. It just depends, it's state by state, and it really depends on what the charge is. And we talk about these issues and more, as you know, Liisa, on our podcast, Constitutional Defenders. So if anyone wants to check us out, we have a lot of stories of exonerations and a lot of our cases and other lawyers' cases as well.
In the Name of Criminal Defense is brought to you by Chartier Nyemphakusa, PLC. in the name of family law.
We are welcoming Kent Wood to the show. Kent is a family law attorney. He is a managing partner and the owner of Wood & Associates with offices in Battle Creek and Lansing. And today we're going to talk about the new discovery rules that started right before the pandemic in March 2020 and how that is helping families save money and helping the attorneys present better cases for their divorce clients. Kent?
Oh, thank you, Lisa. The discovery rule we're talking about has to do with divorces, and it has to do with division of property. And prior to this rule, you had to ask for questions, interrogatories, requests to produce, where we say, answer these questions and give me these things. You had to rely on the other side to do that. And it created a lot of stress, it created a lot of expense. So
Stress for the spouse?
Yes.
Or for the attorneys?
Stress for spouse, and the attorneys.
Both.
When a marriage falls apart, there's a true breakdown, and it could be about finances. But when a marriage is building, there's a division of roles. Some people will take care of the home, and some people take care of the money. A lot of times, when someone's taking care of the money, the other person doesn't really know what's there. So we have to ask the other side in the divorce to become an adversary. They're not going to give that information up, and it can become very expensive trying to get the information because the assets have to be divided in Michigan equitably.
So you mentioned property division, but I think the financial discovery information also relates to child support and spousal support too, right?
Right, because income is a major part of determining what child support is. It's also part of the factors considered in spousal support.
So can you tell us an example of how it worked for one of your clients before the new rules went into effect?
Yes, so one client, she must have spent somewhere between $3,000 and $4,000 just to get some information. They were married
From her soon-to-be ex-spouse.
Soon-to-be ex-husband. During the divorce process, they'd been married 40-some years. They were married young. She thought that there was about $50,000 in the bank account and about $50,000 equity in the home. When we did the discovery, he didn't want to give the answers. We actually had this do what's called a motion to compel, and asking the court again. He didn't do what he was supposed to do under the rules to do it again, and it cost more money to do that. And he eventually did, and we discovered there was close to about $750,000 in assets. So she was entitled to roughly half of that, or some division of that was more equal or equitable. And that was a big difference and helpful for her. But it did cost her an additional $3,000, $4,000 just to get that.
It was a lot more effort on your part. And that probably applies even more so when one of the spouses is self-employed or owns their own business, right?
Oh yes, it's very hard to get a valuation on businesses at times, especially if they're newer but seem to be growing in a growth state.
So do the court rules the new court rules make it easier to obtain this information?
Right now, the court passed a rule in the beginning of COVID time, January 2020. We've actually seen it more enforced in the last 6-8 months in terms of how the judges are going to implement this rule. But the rule requires within 28 days of filing complaining for divorce, you have to provide all the financial information. It's vehicles, bank accounts, debts, the whole financial picture and asset picture that you have to disclose. The other side, when they answer, has to as well. And that's a big part of the initial interrogatories, and it saves a ton of time and money.
So I'm guessing, knowing that this is going to be happening very early in the case, that when a new client comes to your office, you're probably asking them to start gathering that information. Here's a list of everything we're going to need from you. Start gathering it now, because we know it's going to take a little bit of time, and we know it's going to be very stressful for you as well. As you're dealing with the breakdown of a marriage, and you're also having to dig through papers and whatnot.
Yes, so the form requires all this disclosure of all this information, and we provided a list to clients to say, get us all this information. There's a lot of what I call fast and slow periods in a divorce. There's a lot of stuff in the beginning, and then there's a dull time, and then there's another stuff and another dull time. It gives somebody something to do. It's a very stressful time anyway. Here's a direction. Work on this, focus on this. Kind of actually has started to help clients kind of calm the stress a little bit, because they have something to do to move forward in a difficult time. I also have clients, in terms of keeping track of things, it's personal property. I advise them all, go into each room, take a picture of each wall, open each closet, take a picture inside the closet, same with the garage and any outbuildings, just so we have an idea of where things are, because once the family separates, things start to disappear.
So under the old rules, if the person didn't comply, with the discovery request. You would have to file a motion to compel, you have a hearing, you go to court, then a judge orders them to produce it, and then they have time to produce it. And then if they don't produce it, then you do another motion. So is the process different now?
Well, the process is they're supposed to disclose it on the front end. And if they don't, we can go right to the kind of a motion to compel to at least answer the disclosure. It also creates they can't do any further discovery either unless they complete the form.
Oh.
So it kind of limits their ability
They can't get information from your side of the case because they haven't followed the court rules?
Right. And same for our clients. So we make sure they're in compliance so they can get more information. Courts have been deciding not to help you get more information if you haven't disclosed, fully. There's still potential for motions to compel. People, aren't honest all the time, and they may leave some things out.
Well, that's the question I have. What happens if you find out later in the case that they hid assets, or they had a bank account that they conveniently forgot to tell you about? What happens at that point?
Well, we actually had this particular case after this order was in effect, and we had this client that didn't know what all the assets were. We did the disclosures. We did some additional discovery after the disclosures, and through that we found some weird transactions in a bank account, and we found out the husband had a PayPal account, an online account somewhere, where he was wholesaling alcohol. He had $300,000 in this account that was just there. Now, the bad thing that happened for him is that he couldn't dispute what that was. He had to treat it all as a marital asset. He couldn't say some of that was a business thing or anything. That was kind of the punishment there. But it wasn't a clear what was going to be wrong if he violated that thing. That still hasn't really come to fruition yet in terms of the enforcement of this rule.
So I've heard of cases where one possible penalty a judge could impose on the person who hid assets is to use the term disgorge. The judge will treat everything in that account as belonging to the other side.
Oh.
I mean, it's a rare remedy, but it's something that, be warned. There's consequences to you trying to play games, right? And you mentioned the PayPal account. That's really interesting because I think a lot of times people have Cash App accounts or Venmo accounts, PayPal accounts, and a lot of times those accounts are building up money separately, and maybe you maybe honestly you forget about it. Not $300,000 though. You're not going to forget about $300,000, but you might have a smaller amount in account. You got to remember all of those accounts, right? I mean, it's got to be complete, thorough, and all of that.
Right. I think it's the intention, right? If you didn't intentionally forget something, like you wouldn't forget something like that. But the problem is it's so much easier to hide an electronic account because there's no statement that comes in the mail. It just comes to whatever email the person directed it to. And it's either, people have several emails these days.
Great. Well, that was very interesting, Kent, and we hope we have some good relief for clients because they have the information they need.
All right. Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
The new auto no-fault law has made it more complicated for auto accident survivors to pursue and protect their legal rights. I'm here today with Katie Tucker and Steve Sinus of the Sinus-Dramus Law Firm. They're personal injury attorneys, and they want to share with you 10 warnings to help auto accident survivors under this new complicated law. Welcome, Katie and Steve.
Thank you, Lisa, for having us.
Thank you for having us.
We're going to jump right into those warnings. Warning number 1, your insurance company might try to void your policy after a crash and deny all your claims.
Yeah, so when people are injured and they come talk to us at our firm, sometimes we have situations where people are facing a defense from their insurance company that at the time they sold them the policy, the person somehow didn't disclose the appropriate information, misrepresented about something about where they were living, whatever it may be. But there are these arguments the insurance companies can make that if they find out that you were not completely forthright with everything when you bought your policy, at the time when you are making a claim under that policy, they then say the policy was taken out under misrepresentation or fraud, and they can void the policy and then say they're not going to pay you anything for your crash. And that's a very hard conversation to have with people following a crash. So people have to watch out for that, and that means that you really have to be truthful and disclose everything when you buy auto insurance.
Okay, warning number 2. You must know whether your no-fault insurance is coordinated or uncoordinated with your health benefits.
Yes, Lisa, it's incredibly important to know whether you have purchased uncoordinated or coordinated no-fault insurance coverage, because it very well may affect how and whether your benefits will get paid. Under coordinated no-fault coverage, an auto accident survivor is actually required to seek coverage from their health insurer before turning to their no-fault insurer for payment of their medical bills. By contrast, if you purchase uncoordinated medical coverage, which is what we recommend, your no-fault insurer is liable for payment of the benefits regardless of whether you have health insurance or whether that insurance covers the benefits at issue. And again, incredibly important to know, Lisa, because if you are not aware of what type of coverage you have and you're not following the proper rules for pursuing payment of your medical bills may not get paid. And if that happens, you probably are going to lose out on access to critical care services. So very, very important to know and to be cognizant of as you move forward.
Warning number 3, you must know whether your no-fault medical expenses coverage is limited or unlimited.
Yeah, so under the new auto no-fault law, you only get lifetime no-fault coverage if you buy it. And what you need to do if you're injured is understand what are your limits, if any, to your medical expense coverage, because that is really going to tell you the amount of money that you're working with to pay for your care. So when you're injured, you have to be able to do the analysis of what limits are you subject to, and it can be complicated under the law, but you have to know that early on so you can make the right decisions about how you're going to fund your medical care.
Warning number 4, you must notify the proper no-fault insurance carrier within 1 year of the crash.
Yes, Lisa, this is known as the 1-year notice rule, and this has actually existed predating the amendments to the law, but you must notify the proper no-fault insurer within 1 year in writing of the date of the crash. And it's really important that you know which insurer to notify. Generally speaking, a claimant, an auto accident survivor, is going to recover benefits from their own no-fault insurer, but there are many notable exceptions to this. There are complicated priority rules under the statute that you need to be aware of, and so you want to make sure that you know which insurer is responsible for benefits and that you are notifying that insurer within 1 year. And if you fail to do so, unfortunately, you are going to probably lose out on your ability to recover any benefits. So this is a really, really critical warning to heed.
Warning number 5, you must sue a no-fault insurer within a year of them denying benefits.
Yes, Lisa, just like the 1-year notice rule, this is actually called the 1-year back rule. And under this rule, an auto accident victim must pursue legal action within 1 year of the date that an expense was incurred, or they lose out on the right to recover that expense altogether. So if your bills are not being paid, it's really critical that you're tracking that and you are tracking the 1-year deadline, because if you don't file a lawsuit or seek legal action, pursue legal action within that 1 year, you may never be able to recover those benefits.
Warning number 6, you may have important rights against at-fault drivers that are complicated to pursue.
Yeah, so the way the no-fault law works, we buy no-fault insurance, and that covers our medical expenses to a certain extent, our wage loss to a certain extent, and some household services that we may need if we're injured. In reality, people have losses that are outside of their no-fault coverage. And if you have limited medical expenses on your no-fault coverage, you will then need to pursue a recovery against the at-fault driver for your uncovered medical expenses, which you can do. But that's a complicated claim to make under this new law. It's hard to know when that right is triggered. There are certain principles that haven't been established yet by the courts. So that part of the claims against the at-fault driver is complicated. And you also have a right to pursue non-economic loss, or otherwise known as pain and suffering damages. But you have to meet a certain threshold standard, and there are nuances to that legal test. So if you're asking yourself, can I pursue pain and suffering damages? The answer is maybe, if you satisfy these complicated legal standards.
Okay. Warning number 7, you can only recover up to $3,000 of your vehicle damage from an at-fault driver.
This is one that always surprises people. So somebody else causes the crash and say your vehicle has $10,000 of vehicle damage. You would think the at-fault driver has to pay it all. They have to pay no more than $3,000 for your vehicle damage, and the rest has to come from your collision coverage that you bought on your own vehicle. And if you don't have that, you're not going to be able to recover anything other than the $3,000 from the at-fault driver.
Okay, warning number 8, your medical providers are now being paid much less for auto accident related care and treatment.
Yes, Lisa, one of the most concerning features of this new amended law, and this actually just took effect as of July 1st, 2021, is a series of fee schedules that were imposed by the legislature, which significantly reduced, in most cases, reimbursement for medical providers rendering treatment to auto accident victims. And in some cases, that reimbursement's been reduced by as much as 45%. So under the old version of the law, medical providers were entitled to be paid their reasonable charges for accident-related care. Now, under the amended version of the law, medical providers rendering treatment to auto accident victims may face cuts in reimbursement as high as 45%. So unfortunately, I think what we're going to see is some medical providers either forced to shut their doors, as we actually already have started to see in Michigan, which is very upsetting and concerning and for multiple reasons. But also for those who are able to continue to provide care, they may choose to be in the very difficult position of being forced to limit the number of auto accident victims they treat or the amount of care that they can render to those victims. So access to care is really being inhibited.
Warning number 9. There are new limitations on certain types of auto accident related care and treatment care resources.
Yeah, so parts of this law, you have the reduced reimbursement rates to medical providers, but there are also new rules about which type of providers can be paid and accreditation requirements. And there's a lot of ambiguity about that. So certain providers out there might not be able to get paid through no-fault insurance because of these new rules. There are also limitations on how much family members and friends can be paid for nursing care they provide a loved one in the home. It's a limitation of 56 hours a week. So when families are trying to figure out who's going to care for the person, they have to know there are limitations on how much they can be paid, and it makes it a more complicated situation for them to figure out.
Okay, warning number 10. There are new government regulations that can now apply to auto accident related care and treatment.
Yes, Lisa, as Steve mentioned, there is a series of new limitations. We have the fee schedule limitations on reimbursement, the limitations that Steve mentioned, but also a set of limitations in the form of a new set of administrative rules that significantly affect how, when, and whether benefits will be paid, whether a patient, whether an auto accident victim is actually able to access care services. So these new regulations will significantly impact access to care for auto accident victims, and they're very concerning for many reasons.
Okay, well, I'm going to add a warning number 11. Do not go it alone. If you are injured in an auto accident, you really need to bring on an auto accident attorney because these warnings should terrify everybody. You need to know what you're doing, and regular people like myself would not be able to do that without an attorney.
Well, thanks for having us.
Thank you so much for having us.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm.
We're so glad you could join us today for In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.